procedure. This is like the statutory garnishee procedure that the Australian Tax Office uses. A secured party can say, you know that money you owe to the debtor or grantor, don't pay the debtor or grantor, pay me. I'm the secured party. So they can divert the cash flow to them. And that's useful, I'm told, because it doesn't interfere so much with the business. Obviously, if they don't have cash flow, that will interfere with the business. But it's not more distracting than that. So it doesn't cripple the business in any direct sense. Secured parties will now be able to seize collateral and retain collateral. They don't have to sell it immediately. They can warehouse it. So if they're worried about the debtor or grantor dissipating the assets, they can seize them and warehouse them. They can dispose of the collateral, obviously. They could do that at present. But all secured parties can now dispose of the collateral. Some secured parties had no right of power of sale. You know, they had to go to court for an order for sale. Now they'll have a statutory right of sale, these secured parties, all of them. And they can even sell to themselves, subject to certain conditions being satisfied. Now you remember, under general law, receivers could do that. Secured parties might be able to do that, but they had to go to court to get directions. And there are various conditions. These conditions are now laid down in the bill, so they can sell to themselves. And there's even a right of what I'd call foreclosure. They can take the collateral in payment of the secured debt. They can just seize it and keep it for themselves. And that will extinguish the grantor or debtor's interest in the collateral. Now, the Canadian Acts say that that will completely cancel the secured party's claim. In other words, they take the collateral in full satisfaction of their claim. Our bill doesn't say that, but the commentary says that's the effect of the section. But the bill itself doesn't say that, so watch that space. There's a little collision between section 177 and section 433. They provide different orders for application of assets, and I'm not going to go into that in detail. It's a very technical insolvency question, and it will probably be tidied up. It should be. It's been brought to the Attorney General's attention, and it should be tidied up in due course. But there's an inconsistency between the bill and the Corporations Act so far as preferential debts are concerned. One of the most controversial aspects of the new regime is a new duty on all parties, not just the secured party, but all parties, to act honestly and in a commercially reasonable manner. Now, honestly is easy. Good faith, that's easy, no problem. Commercially reasonable manner is the really contentious issue here. Not all lawyers act in a commercially reasonable manner. I'm reminded of a story about, this is probably a very poignant story in Victoria where Underbelly is set, but I'm reminded of a story about Mr. Big, who is doing his accounts. You know, he's got 3 or 4 sets of accounts, as all Mr. Big's doing. He's doing his accounts and he notices there's $1 million missing. And he's very alarmed about this. And he decides he'll pay a visit to his accountant and he'll take his lawyer with him. So they go around to see the accountant. And the accountant's at his desk, beavering away, and he's got his back to Mr. Big when he comes in. Mr. Big comes straight into the room, no good morning, just starts shouting at him, saying, you know, you dirty rat, what have you done with my $1 million? The accountant just keeps typing away, completely ignoring him. And he keeps shouting and shouting, and eventually he spins him around, looks him straight in the face and says, what have you done with my $1 million? And the accountant just looks at him, completely bewildered. And eventually it dawns on the lawyer that the accountant is both deaf and mute. And he says, can't you see he's deaf and mute? And Mr. Big says, well, I don't care if he's deaf and mute, I want my $1 million. Well, what's going to happen? And he says, look, I know sign language. I can interpret for you. I'll ask him. So we'll ask him, what's happened to my $1 million? So the lawyer signs it, you know, the accountant goes, I don't know. He's crazy, you know, I don't know what he's doing. And he said, what did he say? What did he say? And the lawyer says, I don't know, he's playing tough, he's playing tough. He says, ask him, what did he do with it? And he just keeps getting fobbed off, and the lawyer says, oh, he doesn't know what happened to the $1 million. So with this, Mr. Big takes his gun out of his pocket, he puts the gun in the mouth of the accountant, and he says, ask him again what happened to the $1 million. And at this stage, the accountant's really packing it. He's got the gun in his mouth and he's really freaking out about what's going to happen. And he actually tells the lawyer, through sign language, that he's buried the money in a shed at the bottom of his garden. Well, Mr. Big says, what did he say? What did he say? And the lawyer says, he says you're fat and ugly and you don't have the guts to pull the trigger. Now, that's not behaving in a commercially reasonable manner. All parties, secured parties, grantors and receivers are subject to this duty. Now that seems inconsistent with what I said earlier about the enforcement provisions not applying during a receivership. But this one does. This isn't a right, it's a duty. And it applies to secured parties and their receivers exercising rights under security agreements. Now, the major law firms, probably some are represented in this room, put in detailed submissions to the Senate Standing Committee on Constitutional and Legal Affairs complaining about this duty, saying it's unnecessary, it's vague, imprecise, it invites litigation, and it's very difficult to give advice about a standard that's that imprecise. Well, I've looked at the Canadian case law and it's not that alarming, frankly. Most of the Canadian case law follows a very similar pattern to the case law decided under our Corporations Act, Section 420A. The standard is the standard of a reasonably prudent businessman in similar circumstances. And I don't think secured parties or their receivers have much to fear from that. Let me give you an example of a recent Canadian case where the parties were held to be behaving commercially reasonably. It was a quaint little Canadian case in which the secured party wanted to sell some equipment, and the equipment was currently situated at a remote site on the wrong side of an icy lake. And they couldn't drive the equipment across the lake because it was nearly frozen and they were worried about it sinking. They wanted to barge the equipment across to the other side of the lake so that the equipment could be sold at a nearby town to better advantage. And they came to the court and said, can we do this? And the court said, well, the cost of barging is quite high. It's in fact around about the size of the amount of the default under the security agreement. But what alternative do you have? We are not going to second guess you. In this extreme, rather extreme special situation, you are behaving in a commercially reasonable manner, as a reasonably prudent business person would do. So that is fine. I've just got one caveat on that. The Canadian cases contain suggestions that you will be expected to maintain and clean and perhaps repair equipment before you sell it. Now that's not true under Section 420A, the Corporations Act. You don't have to fatten the calf. You don't have to improve the property. You can sell it as is, where is, in the appropriate manner, but you don't have to improve it. This particular test in Canada hints that you might have to improve it. It's only one factor they take into account. Before we leave that slide, it's very important to notice that there's a difference between the new duty under the bill and Section 420 Big A. 420 Big A does not create a cause of action. There's no right to damages under Section 420 Big A, but the new duty will create a right of damages, and that right of damages will be a right of damages available to the debtor, the grantor, guarantors, and other secured parties, subsequent secured parties. Thank you. Let me bring things to a conclusion. There's some new concepts, and we're going to have to discard old concepts. We're going to have to get used to new concepts like attachment and perfection and extinguishment. We're going to be discarding a lot of our old law. The nemo dat principle will go. Bona fide purchase of a value without notice will go. The concept of constructive notice will go. Tacking is largely annihilated. So we're going to have to get used to a whole new set of rules. And the old assumptions, the old preconceived notions should be discarded. They'll impede your understanding, I believe, of the new regime. You've got to embrace the new regime and the new terminology. There'll be new forms and procedures. They'll be required in the financing statement, which will be relatively simple but have to be precise.